Good morning. Hi, Donna. How are you doing?
You?
Oh, look like there's a little bit of a lag there.
It's our little group.
Yeah, my internet was showing that it was off, so I had to go to my box and I just turned it off, turned it back on, and it seems to be okay. But let me know if you guys are having any issues. Hopefully, I'm trying to move around to see if it's all looking live.
Looks good here.
Good. All right. Well, good morning, Catherine. I don't know if she can hear me.
I don't think she can.
Hopefully she's not having issues. Maybe she is. Well, all right. Well, we'll go ahead and get started, okay? Put everybody on mute. Yeah, it looks like she's doing something. So, okay. All right, we'll get started. Here we go. All right. Get my watch. Ready? Error, trusting, policy, matters, season, lots, alone, calling, arrange, collection, purchase, showing, brought, vacation, add, Thursday, secure, comes, inquiry, finish, hands, thousand, talked, purpose, fully, advantage, sometimes, fill, success, shipping, stop, worth, customer, black, afraid, regards, game, discount, turn, stand, true, cause, page, concerning, handle, weight, bear, enjoyed, amounting, obtained, entered, held, total, difference, forget, club, farm, lovely, arm, child, August, charged, brother, serve, felt, government, addressed, hour, entire, enjoy, fellow, guy, looked, September, manner, suit, thinking. All right, names and addresses. Here we go, ready? Ms. Marilyn Brumbaugh, BRUMBAUGH, Business Education Department, Alliance High School, 400, Glamorgan, Alliance, Ohio, 44601, Career Center, Rubidoux High School, 4250 Opal Street, Riverside, California, 92509. Ms. Judy Packard, PACKLARD, Northeast Wisconsin Technical Institute, 1601 University Avenue, Marionette, Wisconsin, 54143. Mr. Michael Bratcher, BRATCHER, Talent Search Office, P.O. Box 3629, Monticello, Arkansas, 71655. Mr. Hamal Patel, PATEL, 471 Piedmont Circle, York, Pennsylvania, 17404. Ms. Dolores C. Grandison, GRANDISON, 8336 South May Street, Chicago, Illinois, 60620. Mr. Patrick J. Cordon, CORDON, 4920 Brockwood Road, number 3, Youngstown, Ohio, 44512. Okay. I've got some antonyms here, and I'm going to give you the opposites. All right, here we go. Calm, troubled, capable, incapable, captivity, freedom, careful, rush, cellar, attic, cheap, dear, clear, vague, clever, stupid, clockwise, counterclockwise, close, distant, cold, hot, combine, separate, come, go, comfort, discomfort, common, rare, conceal, correct, courage, coward, courteous, discourteous, cruel, kind, cunning, simple, dainty, clumsy, danger, safety, dark, light, decrease, increase, deep, shallow, definite, indefinite, demand, supply, despair, hope, disappear, appear, discourage, encourage, disease, health, dismal, cheerful, doctor, patient, dry, wet, dull, clear, dusk, dawn, early, late, east, west, easy, difficult, ebb, flow, economize, waste. All right. I've got some most popular names by state. All right, here we go. Ready? Mississippi, Madison William. So I'm going to give you the first name will be the girl's name, the most popular girl name, and the second name is the most popular boy name. Okay. Alaska, Isabella Aiden. Montana, Emma Ethan. Alabama, Emma William. North Carolina, Madison William. Arkansas, Madison William. North Dakota, Emma Logan. Nebraska, Addison Jacob. Arizona, Isabella Angel. New Hampshire, Olivia Jacob. California, Emily Daniel. New Jersey, Isabella Michael. New Mexico, Isabella Jacob. Colorado, Isabella Jacob. Connecticut, Isabella Michael. Nevada, Emily Anthony. Delaware, Sophia Michael. Ohio, Ava Jacob. Oklahoma, Emma Ethan. Florida, Isabella Anthony. Oregon, Emma Jacob. Pennsylvania, Ava Jacob. Georgia, Madison William. Hawaii, Sophia Noah. Rhode Island, Sophia Michael. Idaho, Emma Jacob. South Carolina, Madison William. South Dakota, Ava Ethan. Tennessee, Emma William. Idaho, Emma Jacob. Illinois, Isabella Daniel. Indiana, Emma Jacob. Tennessee, Emma William. Kansas, Addison Ethan. Texas, Emily Jose. Utah, Olivia Ethan. Kentucky, Madison Jacob. Louisiana, Madison Jacob. Virginia, Madison William. Vermont, Ava Logan. Washington, Olivia Jacob. Massachusetts, Ava Matthew. Maryland, Madison Michael. Wisconsin, Ava Ethan. Maine, Madison Ethan. West Virginia, Madison Jacob. Minnesota, Ava Jacob. Wyoming, Madison Ethan. Missouri, Emma Jacob. Interesting. And that was back in 2007. So I was thinking, somebody had said, well, maybe Isabella because of the whole Twilight series. All right. Moving into a number drill. And I'm going to give you the numbers first, and then I'm going to read you this paragraph. One said 180, then at 200, and then at 225. Okay. 16 feet, 25 feet, 2,800 square feet, 1,600 square feet, 118 feet, 44 feet, 320 feet, 500 square feet, 18 feet, 50 feet. And here's your paragraph. According to the property description, the lot is 60 by 100 feet. The house has approximately 1,500 square feet of living space. The master bedroom is 12 feet by 18 feet, and the other two bedrooms are 12 feet by 13 feet each. There is a family room that is 10 feet by 15 feet, and a small kitchen and dining area. The living room is 13 feet by 15 feet. The house also has 2 bathrooms. Okay, so I'm going to read this again at 200. Here we go. According to the property description, the lot is 60 by 100 feet. The house has approximately 1,500 square feet of living space. The master bedroom is 12 feet by 18 feet, and the other 2 bedrooms are 12 feet by 13 feet each. There is a family room that is 10 feet by 15 feet, and a small kitchen and dining area. The living room is 13 feet by 15 feet. The house also has 2 bathrooms. All right, so now this will be at 225. According to the property description, the lot is 60 by 100 feet. The house has approximately 1,500 square feet of living space. The master bedroom is 12 feet by 18 feet, and the other 2 bedrooms are 12 feet by 13 feet each. There is a family room that is 10 feet by 15 feet and a small kitchen and dining area. The living room is 13 feet by 15 feet. The house also has 2 bathrooms. Okay, I think what I'm going to do, I'll read it one more time at 250. Okay. Yeah, see how it goes. We're not that far off. Here we go. According to the property description, the lot is 60 by 100 feet. The house has approximately 1,500 square feet of living space. The master bedroom is 12 feet by 18 feet, and the other two bedrooms are 12 feet by 13 feet each. There is a family room that is 10 feet by 15 feet and a small kitchen and dining area. The living room is 13 feet by 15 feet. The house also has 2 bathrooms. So I would say that was about 240, not quite at 250. Okay. All right, very good. Moving into word families that have the ability endings. I'm going to give you the words first and then the sentences. Okay. All right, so we've got capability, sensibility, irritability, possibility, excitability, instability, adaptability, acceptability, legibility. All right, I think that's about it. So here are your sentences. Ready? What is the capability of the computer? The legibility of the document is in question. Does the legibility of the contract affect your decision? We are interested in product acceptability. The acceptability of her ideas may cause some problems. She does not use any sensibility when making a decision. John's mental instability worries me. Her instability caused her many problems. What is the degree of adaptability? The consumer adaptability to the problem product has not been proven. Jamie's irritability is annoying. The medicine causes irritability and tiredness. What is the possibility of an acquittal? Is there any possibility of a hung jury in this case? Too much coffee or tea can cause excitability. All right. Now, I've got a basic phrase review. I'm going to read this once at 200, again at 225. And this is just a basic paragraph. And it focuses on can I, did I, to you, of the, that you, when I, is the, if I, did not, I will, were the. All right, here we go. Ready? Did I remind you that Friday, March 29 is the last day to file your application for admission? Can I be of any assistance to you in some of the areas that you might find confusing? On our website, everything is explained in detail. When I sent you the admission packet, were the catalog and test information also enclosed? If I did not enclose those items with your application, please let me know. I will send them to you immediately. All right, so again at 225. Did I remind you that Friday, March 29 is the last day to file your application for admission? Can I be of any assistance to you in some of the areas that you might find confusing? On our website, everything is explained in detail. When I sent you your admission packet, were the catalog and test information also enclosed? If I did not enclose these items with your application, please let me know. I will send them to you immediately. All right. My next drill focuses on possessive your, contraction your, and you are. Here we go. Ready? You are going to win. Your desk is clean. You're the right person. You are going to try. Your home is beautiful. You're a success right now. Your time is my time. You are going to go. You're taking a long trip. You are perceptive. Your worth was great. You're looking very well. You're the best one there. Your car needs washing. You are quite right. You are never late. Your smile sparkles. You're going to be called. Your vote does count. You're falling fast asleep. You are a clever one. You are happy now. Your hair is too long. You're going to do it well. You are seeking him. Your friends are here. You're difficult to see. You are a good salesman. You are here at last. Your bid is the best. You're our last hope. You are saying what? Your car is wrecked. You're leaving today. You're winning the big race. Your future looks bright. You are very prompt. Your dog was lost. You're one to talk. Your test was graded. You are finally there. You are getting the point. Your seat has been taken. You are much too generous. We will hear your side now. You're being very stubborn. You are the last one. Your wife is calling. You're home at last. You're trustworthy. You are dealing now. Your voice is soft. All right, Tangle Tamers. Here we go. Property settlement within legal limitations, land and tenements, transition by will, black leather jacket, estate in fee tail, successive life estates, right of revocation, nature and extent, images and impersonates, alleged or actual, enforceable contract, executory and executed, reasonable apprehension, ostensible authority, discontinuous easement, testamentary disposition, person of requisite age. All right. Consonant compounds. This starts with the initial, well, it focuses on initial BL, final FL, final FT, final TS. Here we go. Ready? I have something in my eye. Here we go. And you're going to hear black and blue. That's just blab, B-L-A-B. Black and white is B-L-A-T. Here we go. Blair was black and blue. The blood was on the house, or the blood was on the blouse. The blockade stopped the blitz. Craig's blindfold was found on the blanket. The blonde was blissful. His blubber made him bloated. Waffles and truffles were served. A rifle was found in the duffel bag. Did you baffle Ray? They left the raft when it was soft. The lift went to the loft. The cats are the pets of Mrs. Potts. We lost the mitts and the bats. Rod sits and waits patiently when he bets. The riots of last year were in Watts. Please total your debts and assets so that we know the profits. The tots slept on the cots and the mats. All right. Moving right into our, we're doing on time. Perfect. Do some literary. We're going to start off with some legal terms and just a legal paragraph, okay? You're going to hear verbatim, testimony, colloquy, defendant, reporter, plaintiff, swears, bailiff, attendance, courtroom, oath, record, jurors, presence, clerk, administers, individuals. All right, here we go. I'm going to read this I'll read this at 200. There are several individuals in the courtroom at the time of trial. These include not only the judge, the attorneys, the plaintiff, and the defendant, but also the witnesses and others and several other individuals whose presence is necessary. The clerk of the court keeps a record of each case that is tried. The clerk administers the oath to the jurors and swears in each of the witnesses. The bailiff or other courtroom attendants maintain order in the courtroom and remain on call to assist the judge in carrying on the business of the court. The court reporter records verbatim all testimony and colloquy. All right, I'll read that again at 225. There are several individuals in the courtroom at the time of trial. These include not only the judge, the attorneys, the plaintiff, the defendant, and the witnesses, but several other individuals whose presence is necessary. The clerk of the court keeps a record of each case that is tried. The clerk administers the oath to the jurors and swears in each of the witnesses. The bailiff or other courtroom attendants maintain order in the courtroom and remain on call to assist the judge in carrying on the business of the court. The court reporter records verbatim all testimony and colloquy. So my next literary for you is going to, we're not going to repeat it. I'm just going to start. I'll start at 180 and move my way to 200. Okay. And I'll give you a word list. We're going to hear budget, monetary, quarter, forecasting, expenditures, objective, alternatives, emergency, household, economic, comparisons, constraints. Here we go. A budget is a statement of monetary objectives for the specified period of time. Every business, household, and government agency finds planning easier when a budget is prepared. An annual budget should be broken down into months or quarters to readily allow for forecasting and planning. The budget is a tool for controlling expenditures and assessing management performance. A well-planned budget will allow for small changes in economic factors and will have built-in alternatives in the case of emergency expenditures. Most businesses and government agencies operate within the constraints of a budget. Budgeting promotes planning on the part of management and allows performance comparisons. A budget is an important planning tool for every business and household as well. So I started at 180 and then worked my way to 200 there. All right. Let's see. I always pick so many different things and then we usually only get through about half of them. Go ahead and put that one away. All right. Go ahead and do some legal opinion. Let me give you a word list. Contemplation, synonym, consequences, duration, calculated, impulsive, schemed, reflections, passion, degree, pondered, rash, deliberate, aforethought, malice, perpetrated, interwoven, premeditated. And I'm just stating this. All right. So I will start, I'll read this at 200 and work my way to 225. Okay. Here we go. The subject of deliberate murder and premeditated murder is interwoven into one issue. We define only murder, which is perpetrated by a willful killing, a deliberate killing, or a premeditated killing when express malice aforethought is present as murder of the first degree. The word willful means intentional. Willful is something that is said or done deliberately. A synonym for willful is voluntary. The word deliberate means formed or determined or arrived at based upon a careful process of thinking and weighing any and all considerations for and against the proposed course of action. The word premeditated means to consider beforehand. Any plan which is thought out, schemed, or planned before an act is premeditated. When you find that a killing was preceded and accompanied by an obvious and deliberate intent on the part of the defendant to kill, which was the result of careful deliberation and premeditation, so that the act must have been performed based upon pre-existing reflections and not governed by a sudden heat of passion or other condition precluding the idea of deliberation, it is murder of the first degree. The law cannot undertake the responsibility of measuring in seconds, minutes, hours, or days the length of the period of time during which a thought must be weighed and pondered before it can mature into an actual intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is based not only on the duration of time, but rather on the extent of the contemplation. A cold and calculated decision may be arrived at in a rather short period of time, but a rash and impulsive act, even though it includes the intent to kill, does not require such deliberation and premeditation as defined by law as an unlawful killing and murder of the first degree. Any opinion is subject to interpretation and consideration because all situations will vary according to the surrounding circumstances. In order to constitute a deliberate premeditated killing, the question of killing must be weighed and considered, and the reasons for and against such a choice must be weighed. With this in mind and knowing the consequences, my opinion is that a deliberate premeditated killing is perpetrated when a person decides to and does kill. All right. Got one more. Jury charge. Actually, I have a land description and a jury charge. So the land description, I will read this at 200. Okay, here we go. A certain lot or parcel of land situated partly in Henderson and partly in Waterbury and on the southwesterly side of the road leading from South Waterbury to Portland, described as follows. Beginning on said road at land now or formerly of Ralph E. Martin, fenced southeasterly by said road of the land of the Free Will Baptist Society. thence southerly by said society land by a road leading to Shaker Village, thence southerly to said road to land now or formerly owned by Henry Watkins, thence northwesterly by said Watkins land and the land of Edward Roberts to a corner, thence southwesterly and to the said Roberts land to a corner marked by a spotted tree, thence northwesterly by said Roberts land to a stone post, thence northwesterly to said Roberts land to a corner marked by a spotted tree, thence now northeasterly to land now owned by Ralph E. Martin to the first main road and the point of beginning and being the Brandwell farm as called and the Randall lot as called, containing 110 acres more or less. My husband used to work for First American Title. He was a title searcher, and he would bring these things home, and I would just look at them and wonder, like, how do you find the exact location? It's crazy, you know? All right, so I'm going to read you a jury charge, and then we'll get on to Q&A. How are we doing with time? Good, we're doing good. All right, so the subject here is income tax fraud. Here we go. And I will start at 200 and work my way to 225. Okay. Ladies and gentlemen of the jury, before proceeding with the court's charge, I want to join with counsel for the government and the defendant in expressing our most appreciative thanks to you for the services you have rendered here and the service that you have yet to perform in this case. I have observed that you have been most attentive to everything that the lawyers, witnesses, and the court had to say, and I have observed also that you have been very punctual in attending, and I know that you will complete your service here in the best traditions of our federal courts. As you have been told, it now becomes the responsibility and the obligation of the court to charge and instruct you in respect to the law, which you will apply to the facts as you find the facts to be from the evidence which has been introduced in this case. Evidence both spoken from the witness stand and the documentary exhibits which have been admitted into evidence. The court proposes also to deliver instructions for your guidance in your consideration of the evidence and in your deliberations upon the case. The instructions which the court will give you insofar as they pertain to the principles of law applicable to this case, and this I said to you before you came on to the jury, must be accepted by you as a binding, controlling guide in your consideration of the evidence and in your deliberations. You will recall when you were examined and later accepted as jurors that the lawyers for both the government and the defendant agreed that you might serve as jurors on the basis of the answers which you made when you were questioned as to your qualifications. The answers you then made to those questions in regard to your competency, qualifications, and your fairness are as binding upon you now as they were then, and should so remain until you are finally discharged from further responsibility and consideration of the case. It would be improper and unlawful for you to disregard the answers that rendered you competent to serve as jurors in this case. Now, again, I tell you that the responsibility rests upon you to determine the facts in this case. It is your exclusive function under the law as to the court may give to you, uninfluenced by any expression of opinion that the court has made or may thereafter make on any matters of the facts. Now, as we all know, this is a so-called criminal case. The law in such cases is that the defendant comes into court presumed to be innocent, and that such presumption protects the defendant until such time, if and until such time shall come, when you believe from the evidence in the case beyond a reasonable doubt that the defendant is guilty and charged in the indictment. You should consider the presumption of innocence with all of the other evidence in the case and weigh it carefully. And if from such consideration of the evidence you have a reasonable doubt as to the guilt of the defendant, then you should find him not guilty. The indictment in this case will be sent to the jury room with you. You will have an opportunity to examine it and to read it carefully. It consists of one count charging in substance that the defendant unlawfully, willfully, and knowingly gave $40,000 to Roy M. Tillman, an officer and employee of the United States, as the defendant well knew, with intent to influence Tillman's decision and action on the matter of the audit made by Tillman of the personal income tax returns of the defendant for the years 2006 and 2007. If you find beyond a reasonable doubt that the defendant, Mark Fisher, gave $40,000 to Roy M. Tillman and that Roy M. Tillman was an officer or employee of the United States, before you can find the defendant guilty of the charge of the indictment, you must find beyond a reasonable doubt that the defendant did this act with intent to influence the decisions and actions of Roy M. Tillman. All right, so we started at 200 and About midway through, the rest was 225. Yes, good push there. All right. Go ahead and do some Q&A. I'm going to just start off with strict Q&A, just two voice. Okay. All right. And I'll, let's see, this one, I'll start at 200 and work my way to 225. Okay. All right. State this. All right, here we go. Do you know a man named Charles Rawson? Yes, sir, I do. Where did you first meet Mr. Rawson? Socially in Laguna Beach about 2 years ago. Do you know Jim Lawrence? Yes, I do. Where did you meet Mr. Lawrence? I believe in December, to the best of my recollection, in San Francisco. Was anybody else present at that meeting? Yes. Who was that? Charles Rawson. Do you see in the courtroom today the man you knew as Jim Lawrence? Yes, I do. I would like to direct your attention now to December. During that month, did you speak with Mr. Lawrence about smuggling cocaine? Yes, sir, I did. Would you describe where that conversation took place? To the best of my recollection, in Charles Rawson's apartment in San Francisco. And was anybody else present at that conversation? Mr. Lawrence and Mr. Rawson. What in substance was said during that conversation? We discussed the feasibility of smuggling cocaine into the United States. I'm sorry, I can't hear you. We discussed the feasibility of smuggling cocaine into the United States, the financing and the logistics. What did Mr. Lawrence say about the feasibility of smuggling cocaine into the United States? To the best of my recollection, Mr. Lawrence stated at that time that he had participated in a successful endeavor and was interested in exploring the potential for further trips. What role, if any, were you to play in the narcotics conspiracy? I was to be the smuggler. And were you to do anything else? To the best of my recollection, I was to smuggle and possibly to warehouse some portion of the drugs that we smuggled in. Were you to obtain other persons to participate in the scheme? Yes, sir, I was. Would you describe what that was supposed to be? I was to put together a team. We were to set up the routing and make all of the travel arrangements necessary to expedite the smuggling. What was Mr. Lawrence going to do in the conspiracy? Mr. Lawrence was involved in the scamming end of it. Would you explain what that means in procuring the drugs? Did he have any other role? To the best of my recollection, that was his role. Was he going to be involved in financing the narcotics purchase? I believe that would have been part of his role, yes, to the best of my recollection. What part was Mr. Rawson to play? A similar role. Did you talk or take Mr. Lawrence and Mr. Rosen up on their offer extended to you in December? No, sir, I did not. Did you reject it immediately? I told Mr. Rawson and Mr. Lawrence that I would go home and consider their offer. I did so, consider it, and decided to postpone acting upon it at that point. And why did you postpone acting upon it? Because another offer was made to me immediately upon my arrival home, and I decided to act on that offer. And what was the nature of that offer? It was of similar nature to smuggle. Smuggle what? To smuggle cocaine. And were Mr. Lawrence and Mr. Rawson involved in that trip? No, sir, they were not. And what again was discussed in the meeting, the next meeting that you had? All the necessary planning arrangements that had been made. All right. Go ahead and find my spot here. All right. This is going to be 4-voice. So we've got the court in this one. So it's going to start off with plaintiff attorney. Yeah, and it is a redirect examination, but defense does come in. Okay, just going to date this. All right, here we go. And again, I'll start at 200, work my way to 225. Now, Officer Newmeyer, you were in possession of information from which you concluded that Mr. Stevenson had information that would be of value to you in the investigation. Well, I will object as being ambiguous, Your Honor. May we have the question, Miss Reporter? Do you follow that question? I would have to answer that yes. As the question was stated, I would say yes. Thank you. Now, what was the case that you were investigating that supplied that information? I was interested in finding out where a party by the name of Cordova was living. I had information that Mr. Cordova was living on Willow Lane within the general vicinity of this particular property, 2204 Willow Lane, Memphis, Tennessee. Did you have any information that indicated to you that Mr. Cordova knew Mr. Stevenson or Mr. Stevenson knew Mr. Cordova? Not specifically, no, sir. Did you have any information that Mr. Cordova was living or might be at Willow Lane? As I previously stated, the information I had at my disposal at that time was that Mr. Cordova was living somewhere on Willow Lane in that general vicinity. And knowing the vicinity, there were only about 3 places that had actual residences on them. And this 2204 was one of the residences that was occupied by Mr. Stevenson. All right, at that point in time, then, you knew that 2204 Willow Lane was occupied by Mr. Stevenson. To the best of my knowledge, it was occupied by Mr. Stevenson, yes. All right, and what was the source of your information regarding Mr. Cordova? Deputy Martin Cohen of the Tennessee Criminal Investigation Bureau. Was that the only source of information that you had regarding this Mr. Cordova? No. All right, what was the other source or sources? General street conversation with individuals that I had arrested, people that I talked to. I had arrested Cordova in the past. He was a large supplier of dangerous drugs, narcotics in the Memphis area. He had done time in the state prison, and he was involved in a lot of other activities in our community. No one in particular, nothing specific other than the information from Deputy Cohen and what I had stored from my vast resources in talking to people. All right, now in connection with your previous arrest of Mr. Cordova, had he ever indicated that at any time he had lived or had business transactions at 2204 Willow Lane? Objection immaterial. Quite material, Your Honor. Goes to the issue of this officer's knowledge, the facts that he possessed at the time that he went there, and whether or not those facts reasonably justified he was going to that location at all. We will hear from you. Go ahead. I didn't hear you. We will hear from you. Go ahead. Well, Your Honor, he said that he had information from Deputy Cohen. What he had found out from Mr. Cordova during the past arrest is immaterial. The question is what he had in his possession on the date he went to 2204 Willow Lane concerning Mr. Cordova. If I may add, Your Honor, he indicated he received information in addition to that which he had from Officer Cohen through several other sources, one of which was his previous arrest of Cordova, and secondly, through conversations that he had with other people that he had arrested and information regarding Cordova's activities as a large drug dealer. Overruled. You may answer. Read the question, Ms. Reporter. Thank you, Your Honor. No. All right. Was 2204 Willow Lane an address that was in any way connected with large-scale drug activities in this area in your personal experience? It would be a matter of semantics with you and me, sir. I don't know what you mean by large scale. Large scale, from the purpose of clarification, would you use in reference to the question in the same context that you used it in regard to Mr. Cordova's activities in this, yes, sir, area? Yes, sir. And the answer is yes, 2204. Yes, sir, 2204 Willow Lane has been brought to my attention as possibly a large-scale traffic spot for drugs in that area. Now, had you made any arrests for drugs at 2204 Willow Lane prior to the date that the time that you were there? No, sir, I had not. Do you know anyone else, fellow officers, that had made such arrests at that address? No, sir, I do not. Then would it be fair to say that your opinion that this 2204 Willow Lane was connected with large-scale drug transactions would be true if Cordova, the man you were looking for, had been there or had activities there? No, sir. Right. How are we doing on time? Good. All right, so I'm going to give you, this again is, well, this is a dissolution of marriage, and it has some colloquy in the beginning, so we'll go ahead and do some of that, okay? And I'll read this, start at 200, work my way at 225. Here we go. Okay, what's the name of your case? Netter, N-E-T-T-E-R. Netter, okay, we can take it up. That was scheduled for a settlement conference today. Settlement conference. and you haven't been able to accomplish much, I take it? Unfortunately, no, Your Honor. William Anderson, on behalf of the petitioner who is present, they're in mediation right now on those issues. I'm pretty confident that we will resolve it, but I've been kind of confident all along that we wouldn't take it this far, and here we are. What issues? I guess the issue of the loan is a big issue. That's a big issue. That's about $120,000 issue. We would hope that we would be able to resolve this, but it hasn't happened. We'd hoped that the other side wouldn't make us put through what we know or have to prove documentarily what we feel that they know happened, but it doesn't appear that it is going to occur. We're going to need some more time. That's now set for trial. It's set approximately 10 days away, I believe. Trial is set for August 26th. August 26th, what's your pleasure? I would first of all object to any kind of a continuance of trial at this time, mainly because my client has had to go to a great deal of expense to be here this entire day. We have fully prepared. We've got our statement of issues. We've got our statements of our income and expense statements. We have our assets and debt statements. Did you deny that there was a loan in your response? Yes, we did deny that in our response. Again, we did not see the matter. What will a continuance avail to you? Well, Your Honor, I'm confident that we can come up with a copy of the check from Sophie Netter. That's my client's mother to the parties. It's indicated from my client that loan is written out on the check. That would be one bit of documentary evidence. Also, I believe that we can locate, I'm sure my client is confident that the respondent has the canceled check showing that the parties paid $20,000 to Mrs. Sophie Netter as an interest payment, interest-only payment, when they refinanced or sold the original house that they bought using the property and the money and purchased the house that they have now out in Moreno Valley. When was that done? That was done in 2008 or 09, Your Honor, I believe. My client denies that there was any such payment. My client left the home in October of 2015, and she left with less than $1,000 worth of property. There still remains in the home approximately $117,000 to $118,000. Your Honor, we're getting off here again. Now of goods and equipment. She didn't get any paper. She didn't get checking account material. She doesn't know what the balances were. She has nothing. So she is at a loss where this claim that she has some kind of a check is coming from. We can trace back through. My client says that there were several accounts that they had in the transaction from moving from Garden Grove, I believe, to here. So we're going to have to check through. How much time do you think you'll need if we can find, so far as the original check is concerned? If mom's available, you can call her, and if she hasn't destroyed it, she ought to be able to find it within a week. Well, that's the problem, is Mr. Netter's mother is ill. You've had your sisters looking for the check, haven't you? Yes, and they've been more concerned with mom's health right now than finding this canceled check, so that's the problem. I don't know whether or not we would be able to find it around the house. If not, we have two avenues upon us. One is to go to the bank where it was drawn up and hopefully get those records. Was it drawn from a savings account? I don't remember at this time, Your Honor. I'm sorry. So we would have to communicate with his mother. Now, is she physically ill, or does she have some type of mental problem too that might affect her ability or reason? She had heart surgery. She's partially paralyzed. She had some paralysis. She can't speak correctly either. When she had all the medications, it damaged some of her vocal. It hasn't been back to her own house. She hasn't been back to her own house now. It's been almost 3 months. She's been living at my sister's house, and they've been alternating care from that point. She's been in and out of hospitals for the last month. Well, it may be that the continuance is not going to improve her condition at all. Well, if I don't know that, it would. I don't know one thing. Maybe she could help us find it. If not, we can find out from the bank that it was drawn on, get a copy of it from the bank. 3, if that doesn't work, then we can take depositions, perhaps not from his mom, because she's not going to be able to respond to much in a deposition, I would think. It's supposed to improve the voice. The vocal cords are supposed to improve, but it's been now 3 months and she's still at a whisper. But his sister, both sisters were present when this transaction was discussed. Well, she went to both for when my father died. All this took place afterwards. So she just talked to them regarding circumstances and what she should do as far as the money and whether she should let him renew the loan or what. So if we had to, when was the case filed? We made a filing on April the 25th. This is the first date set. So it's about 4 months old, or a little less than 4 months old. We started out with a settlement proposal that was never responded to. We have an interest in getting this thing over too, Your Honor. We are trying to keep the costs down. As far as sitting around today, I advised Ms. Hendrickson that I was sitting today. Here's the concern that I have. Even if I continue it 1 month, for example, your discovery cutoff is what, 30 days prior to trial? So you wouldn't have any opportunity to do any discovery. But the court could waive that, could allow us discovery until that time. We cooperated, she submitted. Wouldn't it be cheaper just to have the sister come out here for the trial as opposed to your going back to the East Coast and paying an attorney to take a deposition? You know, well, it may be. We've looked into it, and I think we can make arrangements from our side anyway to have the deposition taken. I don't know about flying your sister out here and inconveniencing her as far as her to testify. I have 2 sisters. Maybe it would be better if we have her here just for the trial as opposed to the deposition. What harm are you going to be occasioned if we continue it, say, a month or 6 weeks? How are you going to be prejudiced? Are you suggesting, Your Honor, in order for me to determine that, are you suggesting that there would be another mandatory settlement conference? No, there doesn't have to be. Just continue it for trial. Okay, we'd be amendable to it. Either way, Your Honor, I think once we get this stuff and it shows, if we can't come up with some documentary evidence, then it's something that we are probably just going to have to submit, and we'd have to have the trial on that. But if we do come up with the documentary evidence, I hope counsel would recognize that and say, okay, this is what it is, and that would resolve it. You want a settlement conference or not? Well, my client cannot afford to engage in this kind of litigation. The prejudice to my client is, first of all, that she has to continue to miss work, and she can't afford that. And I believe here that it's the petitioner's responsibility to, whatever you're going to have, you didn't settle it, right? You need a trial date, so she's going to have to take off for the trial one day or another. I'm just wondering, how would you be prejudiced by having a different date for trial? Well, if there's not a second mandatory settlement conference, we wouldn't be prejudiced in any way. However, I do feel by this additional time, what we're doing is giving counsel an opportunity to create evidence. And I'm really concerned about this. This alleged loan took place. It was really a gift, took place back in 2006, and counsel has talked about it, even the terms of the note, but there's absolutely no information anywhere written. Well, we don't know. He says there is, and he believes there is. Okay, well, I believe, Your Honor, that 4 months is an adequate amount of time for him to have gotten his evidence together, especially when he answered his petition immediately. And then he's the one who set it for trial. We did not, and my client cannot afford to fly back and forth and get depositions or conduct, a major discovery campaign on a $123,000 equity in the home. Well, I suppose when you bought the last home, how long ago was it you bought the last home? I believe you purchased it in 2006. I know that it was the first time. It was in 2006. When was the home sold? In May of 2008. May of 2008, 3 years ago. It might be that a payment was made in the escrow. How was it? You said that you paid your mother $20,000, was it? We owed her mother money, which we paid. We owed hospital bills, which we paid. We wrote my mom a check out, which we paid. And I'm assuming that all of this went out of the checking account. I assume. What bank did you have it at that time? CalFed, CalFirst? I'm not sure. One of the two. When you bought the second home? No, before we bought the second home. Wells Fargo? No. Security Pacific? I'm sorry. I'm really sorry. That was when we bought this home. I'm saying back in 06. We're talking about the $20,000 check that you paid to your mom for the interest. That would have been in 08. That was when we sold it in 08. Okay, when you sold in 08, what account would that have been out of? Well, I don't remember what account. I guess it was CalFirst or CalFed, one of those, CalFed. So we can get that. He does not have that. The respondent has those checks. In any event, I suppose we're going to have to get those from the bank. I think that would be in case. Do you know what the bank is? He said it was CalFed. I assume it was. There were several banks around that period of time, I believe. Is that not correct, Mr. Netter? It was your transaction from Garden Grove or wherever it was to here. I'm trying to remember. But in any event, it was a regular checking account that you were using. Is that correct? Uh-huh. And the $20,000, the source of that was when you sold the house in Orange County. Is that correct? So you put some money down and you had some money left over from the sale. We had $140,000 from the sale of the house left over. How much went down? 10, close to $100,000 plus some costs. So you had about $120,000 to 120,000 plus to pay different expenses with and repay loans and that sort of thing. So you're currently set for trial on the 13th. No, the 26th. 26th. Thank you. That's another day that I'm scheduled to be down in Department F3. So that day is not convenient to me. I'm sorry, Your Honor. Well, we're now on the 12th, right? Today is the 12th. So would you want to continue to how much? I think 6 weeks would probably give us enough time. 6 weeks from today or 6 weeks from today would do it. Don't you think we can get the records back from the bank records back from there? Either that or a deposition or, okay, Your Honor, if you are going to consider this, their request, Your Honor, I'm sorry, a continuance, I would request that as part of that order, that petitioner be required to provide the documents responsive to our production request. Your Honor, we gave her a package. Let me know what you don't have that you requested. There's some in there in that package. What day would be better for you, the 23rd or the 30th of September? Your Honor, just in case, I think the 30th would be better on my calendar. I'm sorry, what are the dates that you suggested? The 23rd or the 30th of September? Yes, the 23rd would be better. Okay, the 30th would be better for you. The 30th would be better. And the only reason I say that is that right now we're anticipating Commissioner Reichs would be back on the 13th. If she's not back then and I'm still filling in, I'll be sitting down there on the 23rd. I don't want that to happen again, what happened today. And I have a trial on the 1st of October. On the 1st of October, right, which is the day after the Monday. It's a jury trial, and that's why I've selected the 23rd of September. Any other date during that week is fine too. I don't know if the court was, all right, the 24th, 25th, 26th. Those are fine with me. The 26th, I've got a trial, so I wouldn't want to double up on that. 24th, 25th, the 24th or the 25th would be okay. The 24th, Tuesday, better than Wednesday? Okay, September 24th, 8 o'clock in Department F1. Thank you. And then tell him, let him know what it is that you want that he hasn't furnished to you, or tell me. He hasn't furnished us with any income tax records, Your Honor. That is really crucial, and we've asked several times. Do you have your income tax returns? Do you have your income tax returns yet? They're in the car. They're in the car. Okay, we'll get them to you today. You couldn't find 08, was that? Right, I have 09 and 2010. I don't know where 08 is. 2009 and 2010. Who did them in 08? Do you know? We did them jointly in 08. We did them jointly in 09. We did them separately in 2010. But you didn't keep a copy of the return? I did, but I can't find it. I can find 2006, 07. I can't find 08. I've got 09. You can, I guess, get a copy from IRS. She can do that, Your Honor. Okay, either one of them. It's not going to tell us anything anyway. Well, if it shows an interest in the expense, that's true on that, yes. It might be support for your contention that you made a payment on the loan. That's true. What else, counsel? We haven't obtained a full mortgage statement. It's equally obtainable. Your Honor, this is some of the stuff too. She wants us to do her legwork for her. She can go down to the mortgage company and see how much she paid on this loan and get that. She'd rather send us off running, scurrying to get it. That's the point of this. Your Honor, my client is not in the home. She doesn't have any of the documents and the records, and Mr. Netter is the one making the payment. You don't have to get it for her if it's equally available to her. But if you have it in your possession, like a payment book or something like that, records from the bank, please furnish her with it. Well, Your Honor, she wants 3 years of checks from the time we moved into the house, and I don't know if I can come up with 3 years worth of checks. I supplied the numbers. I supplied a statement to her today showing her what the statements were and the buyout was. I supplied her the last, since she moved out in June, all of the canceled checks. She can just call to find out whether it's current or not current or how much was paid. It's equally obtainable. That's not quite accurate, Your Honor. The payments on the house, you want the payments on the house for the 3 years? No, we've not asked for the payments on the house for the last 3 years. Not at all. We've asked for the 2015 mortgage statement on the first and the second trust deeds on the house on Candlebrush Court. If you have those, if you have them in your possession, then make a copy of it and give it to her. Everything I have has been supplied to counsel. We've also asked for copies of the documents that support the bank card. The MasterCard is a community property debt, and we have not received any documents other than the billing statements that have occurred outside of during the separation period only. That's not true, Your Honor. I supplied statements starting in September, and it is the respondent's contention that we separated in October. So all of the billing statements prior to the separation and has been supplied. Everything that I have has been supplied to her. When did the MasterCard start? September. September was when it was opened. It was first started. That's when it first was being used. That's right. And we were still reconciling through December. I don't know. I can urge them to comply. You could bring a motion to compel production. How'd you do?
There's a lot of red down there. That's hard when it's called you back and forth and back. That's really hard.
Yes.
And I've had that happen in court. And I was like, oh, how do you guys do it? It's tough.
Yes, especially like when they're talking about calendar, because they just start throwing out lots of dates. Like, well, what about the 12th? No, the 12th doesn't work for me.
No, yeah.
And it's like, wow. Yes. Yeah. Calendar tends to be tough. The good thing is most of the time they don't, ask for a copy of that because, but you never know when they're going to say, hey, can you repeat what date we just said that works?
Yeah.
You better have it.
I just did proofing for another reporter, and it was all the jury, like the jury voir dire that usually isn't reported, but they wanted a mistrial, so she's having to do all of it. And there's so much of this, just back and forth, and all these different jurors, and oh, wow.
Yeah, so you're proofing that, huh?
Yeah.
That's awesome. That's awesome. Now, did you get in for the test, the state test?
I applied, and I was trying to, my master plan was to try and take the written portions this month.
Okay.
Which I did get qualified, and I have the information back from the Court Reporters Board. But apparently it takes some time to you have to get a code, like a registration code from the testing agency. And that takes some time, so I may not be able to fit it in October, which if I didn't pass one of them, I'd have a chance again next quarter, like starting again in November. So that's why I was trying to fit it in October. I think I'll pass, but you never know.
Right.
But anyway, so yeah, I'm in for the 1st of December for the skills.
Good.
For that.
Good. Oh, I'm so excited for you.
And I went to the convention this past weekend. And that was great. And I took a lot of classes and took the mock, made a mock CSR there, and that was totally fine.
Oh,
and
good.
Yeah, they did they read the last test from July. So it was completely fine.
Oh, yeah. I'm so glad.
So we'll see.
Yes, you got this.
Yeah, we'll see.
You've got it. Yeah, you're ready.
I'm ready right now. I want to do it right now. So I'm not fly to Sacramento and
just keep practicing,
Yeah.
I think sometimes people go, oh, I'm ready. And then they kind of slack off. And then all of a sudden it's like, oh, you just want to go in feeling as confident as you can. So just keep putting in the time. Yeah. As if you've got to, just pretend like you're still getting through school and put in that time. Yeah. I think that's where it gets a lot of people. Like when they, like at the school, when they would qualify, it was all of a sudden, a lot of students would think, oh, okay, now I can kind of kick back. It's like, no,
it's like you met that goal you've been trying to get to all the time. You've done it. And so you're like, shoot, done, but you're not done.
No.
And
yes.
You're right. It's hard because now I've got scoping and proofing coming out my ears. I've got studying for the written exams, and I still got to work on my machine. So I'm busier right now than I ever have been, really.
Yes.
So got to keep pushing forward.
Yes. Yep, that's right. Oh, I'm so happy for you. You're going to be an awesome reporter.
Thanks for all your help and everybody. Once I get there, I'll send you guys all cookies.
Oh, Donna, I'm so happy for you. I wish it were in LA. I would go to LA and meet you there.
I want to talk to you when we're not taking up time online. I want to talk to you about depositions because I don't know a lot. I just need to maybe pick your brain about depositions.
Yeah, I loved them. I mean, I really, really loved them.
I need to talk to somebody who loved them. Yeah.
Yes. But then my friends that work in court love court, and they're like, ooh, depositions make me nervous. I'm like, what? To me.
That's how I feel. I don't want to feel that way, so I need to talk to you.
Yes. And to me, court always, to me, was more intimidating.
I love court. I'm like at home in court.
Isn't that so? Everybody's different.
Weird, huh?
It
Yeah.
is weird. It really is. It really is. Yes, I will. Do you have my number?
Yeah, I have your number. Maybe
Okay.
we can
Yep.
just have a time and like when we're both free,
Yes.
we can
Just
chat for
let
a
me
little
know
while.
when it
Okay,
works for you, and we can talk
awesome.
on the
That's
phone.
so kind of you. Thank you.
Okay. Yes, absolutely. I would love to. I've got funny stories and
Oh,
just
cool.
things that I learned to do, not to do.
That's what I need. Yeah. So
Yeah.
I'm not so concerned about it. And I think really that it would work better for me in my life right now. Although I really want to be in court, I think depots, once I got comfortable, I'd be happy.
Oh yeah. Yes. And that's the great thing about it is if like you have a day where, you're busy and you don't want to work. Like I remember, I would always tell my agency, like I work on the kids class on whatever day it was, Wednesday or Friday. And then they never put me on the calendar, but that
Right.
on that day. So it's very flexible.
Exactly. I've got a family. My daughter's taking piano lessons. I always take her to piano. Like I don't want to miss piano lessons or recitals or
Yep.
gymnastics events. So yeah, I think it would work better for me right now.
Yes. And then, sometimes, if the witness doesn't show up, you still get an appearance fee and then you let your agency know, hey, they didn't show. And most of the time they would have another job, like a last
Yeah.
minute job. And they would ask you if you had time to get there,
Yeah.
and they would even like, I remember showing up to like a job that would be at 9. And if the witness didn't show, they'd say, oh, well, we are scrambling to get a reporter, across town. And we can tell them that you're just going to be late because you're going from one job to, and I mean, so really you're getting double pay because you got
Yeah.
paid for showing up and, the appearance fee, and then you're getting paid again for actually going to another job. Or you can just say, oh, I'll just take the rest of the day off. It's totally up to you.
Right. Well, I'm
So
like, I've been in school for what, 5 years, like way too long. And we haven't taken a big family vacation. We haven't done any of that stuff because I've been in school like all this time. And talking to the reporters over the weekend who are in court, they do love it. They're like, oh, I'm kind of low on the priority. I'm not getting vacation. I won't have vacation for so long, or I'm not getting any time off. They're at work all day, which I don't mind, but I do have things that because I've been in school, I have the freedom to go and do other things with my children and whatever. So
yeah.
I don't want to lose that yet
Yes.
for a couple
Absolutely.
years.
Yes, you can always start at depots, and then when your kids get older and then they get busy doing their own thing, then you could always go to court,
Right. When she can drive herself in 3 years, maybe I'm off to court.
Yeah. Yep. That's right. That's right.
But I could also do pro tem for a little while and kind of
Yep.
keep it that, get my
Yep.
foot in. Because they also said, and I'll stop talking, they also said so many people are retiring right now from the court that if you get in now, then your seniority will climb so much more quickly. And so it's a really good time to get in.
That is so true. A lot of baby boomers are retiring, and
Right.
it used to be where, you'd have to start at pro tem and it would take, years to get into an actual position. Not now. I mean, we had right at the end, right before Sage closed, we had a student that graduated and she got a call to pro tem out in somewhere out past Palm Springs. So she went out and the judge liked her so much. And he said, my reporter is retiring and I really like you. Can I hire you full time? And she took it.
Awesome.
I mean, her first time being there, it's crazy. They're in such need,
Well, that's meant to be, so maybe that's going to happen. And maybe just once, what, I got to focus on California test and then I can focus on.
But it's exciting that, you're finally there where you can think about the options. Yeah. So, all right. Well, Donna, you call me or let me know whenever it's good for you.
Okay. Awesome.
Okay.
Thank
Have
you,
a good day.
You too.
Okay.
Bye.
Bye.